I'm Larry Kolvig, founder and CEO of the Haven Financial Group. Give us a call at 612-504-8400. Ask us questions. Set up some time to come in. We'll sit down, ask a lot of questions. You can ask us lots of questions. It's a laid-back atmosphere, but you may learn something that you didn't know, and maybe we can help you. If you're looking to get help in any of these certain retirement areas, I call them the puzzle pieces, putting all the pieces to retirement together so you're not missing a few when you finally get to the end, and that being in the golden years. So, Cammy, it's great to have Lance on, again, our in-house CPA. We're going to talk estate planning. Normally, oftentimes I'd have Carrie in on this show with me, but I have years of estate planning. But her, Anna, and Keith are the estate planning attorneys. But this also is going to be a good conversation.
Absolutely. Well, we've talked about, gifting and inheritance taxes and sort of the taxation portion of estate planning. So now we wanted to back up, if you will, and just talk about what are some of those key legal documents that you need for a good, effective estate plan. So let's start with last will and testament. Why don't you walk us through some of that and some of these other legal documents?
Yeah, and I think I'll redirect that a little bit because I classify these into living documents, documents needed, or I hope you don't need them, but you may need them when you're alive.
Yep.
And then when those documents, you're no longer here, documents that you should have or at least look at. And those living documents are, I would say, when you're in capacity, you're capable, you're able. Those starts with simply the durable powers of attorney. Mm-hmm. Who have you given the authority and the financial, the medical records, healthcare? Who have you given legally access to? And right now, listeners are thinking, well, I've been married for 50 years. My spouses have automatic authority. They do not. They absolutely do not. So you need to appoint somebody, a friend, a neighbor, whoever that may be. And sometimes I get this response, well, I don't even know who. Well, name somebody that you would rather have, because the alternative is the state that you live in. And that could be guardianship, conservatorship. And that means who's your parent if you're unable to speak for yourself, who has your checkbook and who's in charge of the money if you're unable to tend to your own business. So those are the living documents. And anybody over the age of 18 should have those powers of attorney, any legal adult. And I know Carrie, our estate planning attorney for graduation gifts, that has discounted her costs, or actually she may even give them out to young graduates. So even though younger generation, our daughters at their age in college, they all have theirs because thankfully I'm practicing what I preach. And I had to be reminded when our 18-year-old, because these things can just kind of go by you. So the healthcare powers of attorney, the living wills, those terrible types of things that you want to have life support, resuscitation, those aren't fun conversations, but if you have kids, they might have different ideas, or dad wants this, mom wants this, and maybe you don't want that. Mm-hmm. But if it's not legally drawn out, it's as if it doesn't even exist. And these living documents would have to have, as of 2003, we called it HIPAA, the Privacy Act.
Right.
The verbiage needs to be in there, the protection of your privacy, the HIPAA authorization. It's actually legalese in the documents. And that's where, if you have old documents, you should get them reviewed because they might be outdated. And I know the tendency, and I'm not against doing it yourself, but in some areas, doing it yourself is not the right answer. Are you an attorney? Are you not an attorney? These should be legally done. And I'd be very cautious of people that sell paper, Susie Orman and others, hey, respect them and all this, but there's different rules in different states, and sometimes we call them selling paper, and it's not even good as the paper it's written on. Mm-hmm. So be very careful. LegalZoom, some of those other things. Yeah, you may be okay, but I'd rather take the may out of the equation and say, you know what, we had them done right, and they will be okay.
Mm-hmm. Right. So really, we're talking about anybody over the age of 18 needs all of those documents.
We are.
Yeah. Absolutely. Because after 18, you're making your own legal decisions. Your parents are not your guardians anymore, as far as these kinds of legal situations are concerned.
Yeah, the release of information. God forbid your kid goes off to college and breaks a leg or gets hurt or an accident. And if they haven't given you consent, they can't talk to you. So you have to go ask the permission.
Right.
And Kim, then it goes into, oh, what if we're not here? Then what documents take over? Well, hopefully the documents you have had legally prepared when you're not under duress, not under stress, and able to speak. And that would be what's called the last will and testament. A will is your wishes for what you want when you're gone. It's your wishes. It designates who you want to be guardian over your kids. It can designate if you're not here, if you die, what happens. But it's really your wishes. It does not
not your
probate.
Right. It's not about your assets. It's about your wishes.
It's about your wishes. So it's your wishes for the probate court. If your estate is over, I think it's 75,000 of titles, deeds, and accounts in the state of Minnesota. Otherwise, that would have to go through the probate court, through a probate judge. Many listeners may have gone through a not so fun experience if you went through that. Not that all are bad, but they tend to be costly, time-consuming for the kids or loved ones or whoever's benefiting. So it's why a lot of people look at a revocable living trust that is an entity designed to hold your assets, titles, deeds, accounts. Our house is in the Larry and Rochelle Colvig Family Trust. And anybody trying to find it, by the way, trusts are private, so good luck trying to find where that is, okay? It's the beauty of a trust. It is a private, where a will is public. Once you're gone, if you're dealing with probate, they're going to announce your stuff. There's going to be a certain timeline, and there's nothing private about it. And most people tend to be more private, so a trust may be the thing for you. It's not for everybody. There's some financial people out there that say everybody should have a trust. I say that's not true. How do you know? Sit down and talk with somebody and have an evaluation to say it makes sense or it doesn't make sense. It's revocable. My wife and I are the trustees of our trust. Nobody can change it but us. When one of us is gone, we've chosen to make it, for the most part, irrevocable, so somebody doesn't, if anybody can't come in. So a trust does avoid probate. Now, if it's not necessary and you own a piece of property, we're going to have Carrie or whoever you work with should talk to you about a transfer on death deed. It's a tool, not a detailed plan like a trust is. It's a tool that maybe suffice to avoid probate on any property. These are the documents when you're gone or you passed away. And I know there's some people that give this advice. Well, if you're married, don't worry about it. But if if one of you passes, then the other one should do it. You do all your things together for all these years. Do not wait till one of you, because what if you go together? I think that's terrible advice. If you're a married couple or partner, you should do this when you're capable, competent. And by the way, we've made estate planning, these things, kind of a senior topic. Yeah. It should not be a senior topic. When you had kids, got married, bought a house, and started getting assets, that's when it was intended to be done.
Well, and what people I think have to remember is this has to constantly be updated. So what was important to you when your children were minors might change when your children are adults. And another thing, Larry, it's you who has said this over and over, and I actually started talking to my husband about this. You have to double check your beneficiaries. When we were younger and we didn't have children, our parents were our beneficiaries. We had them on a lot of our documents. Well, now we have adult children. They clearly would now be our beneficiaries. And we have gone back through to double check and make sure that everything is in their names now versus my parents or my in-laws.
It's one of the most simplest things. Some would call it elementary, but we ask it in all our conversations and who we work with, if they're coming in, if they're new, who are your beneficiaries? And most of the time they say, well, it's my kids or whomever. But is it on the actual accounts? I can't tell you how many times in all the years I've done this where there have been no beneficiaries. And again, I made this comment before on the show. I was with a couple. She was a 41-year nurse at Fairview Ridges. And they were in my office and just the most wonderful people. And I noticed on her 403B at work, mind you, 41 years, there was no beneficiaries. And I asked her, I said, you have no beneficiaries? She goes, I don't know who to put. Your husband is sitting right next to you. Oh, yeah, I guess I should put him. Uh, Thankfully, nothing happened, or
Yeah,
ex spouses that were on there, and or just none. So
sure.
make sure your beneficiaries are current. We're going to talk more in the next segment about different things with that, but so often they're outdated. There's not
Mm,
there. Make sure something as simple as beneficiary designations avoid probate. And if that's your intent, you probably should do it. On the living will, healthcare directives, that type of thing. I mentioned starting this coming year, Haven Financial Group, to our clients, we're going to provide a now what. It's a nice book to document all this information, whether you're alive or still with us, and when you pass. The more information you can give to your kids or loved ones, and sometimes people say, "Well, I don't really care; they can deal with it." Now, most often they don't really mean that,
no, right.
but for those that do care and want to make it as simple and seamless as possible, this Now What Haven financial book, if you will, we're going to give it to our clients, and you can put as much information, funeral, what
Mhm.
you want done, who you want to do what, and it's going to be very helpful. And already people go, I love that idea. So
Absolutely.
again, these things are not fun to talk about, but they're so important. Proactive, not reactive, because in this world, reacting is not going to it's not going to bode well.
No, it does not. Absolutely. So, do you need legal documents, some of these legal documents that we've talked about, or maybe you have some and you need them reviewed? Let's make sure that your estate plan is airtight. 612-504-8400. That is the number you call, set up a consultation with the Haven Financial Group. They would be happy to go through the documents you currently have. They are happy to draw up new documents and, of course, so much more when it comes to your retirement planning. 612-504-8400. You tell them that you heard Larry and me right here on the radio and that you'd like to come in and sit down and chat.